And we're ready to resume with the trial. The record will reflect that both defendants are in court with all attorneys present as well as prosecution is also present. Witnesses on the witness stand. Would you state your name again for the record, please?
Erik Menendez.
I'll remind you that you're still under oath. You may continue your cross-examination.
Thank you, Your Honor. Mr. Menendez, yesterday we were talking about the Billionaire Boys Club movie. Do you remember that?
Yes.
And did you in fact tell Dr. Ozio that you had seen a BBC movie?
Objection, Your Honor. Asked him answered.
No, I did not.
But you are familiar with the Billionaire Boys Club?
Yes.
And you indicated yesterday that you're familiar with what you called a mini-series.
No, I know there was a miniseries about the actual case. I'm familiar with the case.
How did you know that there was in fact a mini-series on the Billionaire Boys Club?
Because Brian Eslamania, my friend, I think I even knew about it before him, though. I don't know, it was a big thing when it came out. It was a big television movie.
Now, Brian Islamania is the son of the father who was killed, correct?
Yes.
Now, calling your attention to a conversation that you had on November 29th, 1989, did you refer to forming a group like the BBC?
No, I didn't refer to it like that.
Did you refer to forming a group of 4 people, as you put it? The person you were talking to, a person named Brian, John, and Dave.
I'm going to object to this calling for hearsay.
Objection sustained. This will be evidence offered at a later time.
With regard to the session that you had with Dr. Ozio on October 31st, did you tell Dr. Ozio, after talking about this movie on the BBC, did you tell him that there was no way to link you and your brother to the crime?
No, I did not. I said just the opposite.
You said what?
I told him about the guns down in San Diego. We had a long conversation about that.
And you told him that you could be easily linked to the crime because someone would know that you used Donovan Gaudreau's license in San Diego. Is that what you told him?
No, that's not exactly what I told him.
What did you say?
I told him about the gun purchase in San Diego and how Donovan had called the police the next day and how Detective Zoller told me about, I told Lyle about Donovan on the 17th, I'm quite sure, and how it was purchased with Donovan's license. And I also told him about the video cameras. And I was asking him how long tapes stay on video cameras and so on.
And did you, in fact, call down to the Big Five in San Diego to find out about that?
No, I did not.
Now, so it's your belief right after the killings that you would be caught?
Oh, I definitely believe that.
So you never told Dr. Ozio that there was no way to link you to the crime since the fingerprints in the house were your fingerprints, since you lived there, and there were no witnesses. Did you ever tell him either of those?
I told him that I didn't think there was any other way to link me other than the guns.
And did you in fact tell him that the guns had not been recovered because you hid them down a hillside off of Mulholland Drive?
Yes.
So you told him that the guns had not been recovered, correct?
Yes.
And you told him that you believed there was no way to tie you and your brother into buying the weapons in the San Diego gun store, correct?
No, I told him just the opposite. There was an easy way, and that's what we discussed. That's what I was concerned about.
The police, are you saying to these juries that the police would run everyone that you or your brother ever knew in your life to determine if they had bought the shotguns?
No, what I discussed with Dr. Ozil is that I figured that chain stores or something to do with gun records were held on computers, and that all the police would have to do is, and I knew at the time they suspected us highly, that all they'd have to do was run names in the computers and find out when guns were purchased on what days. I was concerned about that.
But they didn't know at that time that you had used fake ID, did they?
Objection.
rephrase the question, please.
Is it your state of mind that the police knew that you used fake ID in San Diego to purchase these shotguns, sir?
No, I really didn't think that because I bought them in San Diego, it really mattered. I thought there was a statewide computer. Actually, I thought there was a national computer. But I once I found out they knew about Donovan, that's when I got concerned because I thought all they'd have to do was punch in the name in the computer.
You have a knowledge about computers, it appears, sir. Is that right?
Actually, I was wrong. They don't have a statewide computer.
But that was your state of mind before this occurred. That went to your state of mind when you spoke to Dr. Oziel.
Yes.
So you thought about computers and you thought about a statewide computer and you thought that they could punch in certain information into the computer?
Certainly.
So when you testified that you didn't know anything about computers, was that inaccurate?
No, I really don't know anything about computers.
Had you ever had any interest in computers?
My dad bought or brought home a computer when I was like 13 or 14, and I had an interest in it then because you could play the video games on it.
So you had worked on computers before?
No, not really. I hadn't done any assignments on them. I just fiddled around with it though.
You turned the computer on and you accessed information?
Yes.
You knew something about computers?
No, not really. I didn't know much. I didn't know the computer that he brought home was one of those old style computers, not like the computers nowadays that are apparently real easy to access. It's real complicated, and I screwed up on it.
So when Dr. Oziel testified that you had told him that there was no way to link you to the guns that you and your brother purchased in the San Diego gun store, he made that up? Because you actually told him that they're going to find out because they know that I use fake ID in San Diego.
No, I didn't tell him that. We had a discussion about Donovan and the video cameras.
You actually mentioned this person's name in the video cameras to Dr. Oziel.
Yes, we had a long discussion about it.
And you told him that you would get caught because they would run something on a computer.
No, I told him that that was the only way I thought we might get caught at that point.
So you told him that was the only flaw to your plan.
No, I told him that that was the only evidence the police would probably have at that point, since no witnesses have come forward and no one linked us in any way. And so that was the only way I thought at that point they could find us.
Now, you just used some interesting language. You just used the language that Dr. Oziel said you had used, that no one could link you in any way.
Objection sustained. Why don't you rephrase the question, please?
You had just stated, sir, that you believe no one can link you in any way other than that, correct?
Yes.
And that's what Dr. Oziel testified that you said, didn't he?
Objection argumentative.
Overruled.
That's what I just said, and that's the conversation we had with Dr. Zeal about how we could be linked to this, and that's when we talked about, actually, we talked about what the police knew, and that's when we talked about the guns.
Now, you told Dr. Oziel at that time that the police had not recovered the guns because you hid the guns, correct?
Yes.
And that you did inform Dr. Oziel that you bought the guns in San Diego using false identification, correct?
Not in those, not in that language, but yes.
At that point, did Dr. Oziel indicate to you that he wanted to have your brother come in on the session?
Yes.
That's after you had told him what led up to the murders, what you did in breaking in or bursting into the room, shooting your parents, and what you did afterwards with respect to the evidence.
No.
Objection compound.
Overruled.
No.
What did you tell Dr. Oziel before Dr. Oziel said, let's call Lyle and tell him to come into the session?
I talked.
Objection asked and answered.
Sustained.
At some point, were you present when Dr. Oziel called your brother
Yes, I was.
and asked him to come into the office,
Yeah, he called him on his phone.
and your brother came in?
Yes.
Now, you said that it took your brother a while to get to the office, correct?
Yeah, longer than I thought it would.
And during that period of time, there was more discussion about what had happened?
It was more discussion about what my parents were like.
When your brother arrived at the office, he wanted to find out what you had told Dr. Oziel, correct?
No, just the opposite.
He did not want to know anything.
All right, this has been answered now.
Overruled.
Dr. Oziel wanted to tell him, and Lyle said, "No, I don't want to know. I don't want to hear about it."
At some point, he learned that you had told Dr. Oziel what you and your brother had done, correct?
Yeah, he wanted to hear it from me. I did not want to discuss it with Dr. Oziel.
He found out at some point, sir, that you had implicated him in the killings of your parents.
Yes, I
And
think he suspected it as soon as he went into the session, though.
something was told to him in your presence in that regard. Is that right?
Dr. Oziel said, I think on the phone, Erik's told me what happened or something like that.
So he knew coming in what Dr. Oziel meant.
Objection, Your Honor, calls for speculation.
Sustained.
Was it your state of mind that your brother already knew by the time he arrived at the office?
Objection, Your Honor, irrelevant and based on speculation.
Overruled.
No, I thought that from what I heard on Dr. Oziel's end, that Lyle was probably pretty nervous about it. And I was right.
And when he came in, did he appear to be nervous?
Yes.
And did he immediately become menacing?
No, not immediately.
Okay, how long did it take?
He got angry. I don't use the word menacing. I'm not quite sure the exact definition, but he just got angry and defensive with Dr. Oziel. And was saying that he didn't want to be there. He didn't want to know what I had told him, and he just wanted to talk to me.
Did he get into a fight with you and yell at you for telling Dr. Oziel what you and he had done?
In front of Dr. Oziel,
Yes.
I don't know. He raised his voice once or twice. I know that.
Directed at you?
Yeah, basically saying that, why I couldn't tell him and why I had to go to Dr. Oziel.
Now, at that point, had you told your brother that you had told anyone else about you and he killing your parents?
No, I hadn't.
So this was the first time that your brother was aware that you had exposed the two of you as killers.
Yes.
And you had discussed earlier that it would be less of a risk if the two of you actually committed the killings yourselves, correct?
No.
You had discussed, you had not discussed that at all?
Objection, I asked and answered yesterday.
Overruled.
I don't understand what you're saying. You discussed that it would be less of a risk if Lyle and I did it ourselves.
Yes, that no one else would know, just the two of you, and you would not have to rely on anybody else.
No, that was never discussed.
Now, it was your brother's belief, though, at that point, that only you and he knew that you and he had killed your parents.
Objection, calls for speculation.
Overruled.
Yes, I believe that was his belief.
And now he understood that Dr. Oziel knew what the two of you had done.
Yes.
And he was angry.
Yes.
He was angry that you had told Dr. Oziel what you had done.
Yes.
And he was angry with Dr. Oziel.
Yes.
Did your brother state at that time that it wasn't a perfect murder anymore, that you caused him a very big problem, and that the doctor now knew what you and he had done?
No.
He never made any comment like that.
Definitely never made any comment
In
like
fact-
that. My brother doesn't talk like that.
Maybe you can share with these juries how your brother reacted.
He reacted in saying, I don't want to be here. I don't want to know what you know. I just want to talk to my brother. Dr. Oziel said, well, we can talk about it. And Lyle said, I don't want to be here. And he just wanted to get out of there.
Okay. You have testified that your brother was angry that he was yelling at you. He was angry with Dr. Oziel. Did he make any statements regarding his displeasure with you about telling Dr. Oziel? And how
Yes,
it co-
I think he may have used the word he felt betrayed or something to that extent. He felt like I should have told him instead of Dr. Oziel if I was having.
When he said that he felt betrayed, did he point out to you that now it's not the perfect murder, now somebody else knows? Now it's not just you and I. It's now Dr. Oziel as well.
No,
Did your brother in your presence tell Dr. Oziel that he didn't want anyone looking over his shoulder and controlling him, and that's why he murdered his parents to begin with?
no,
Did your brother in your presence tell Dr. Oziel that he was very unhappy, that he'd have to think about what he was going to do with this situation, about Dr. Oziel knowing what you and your brother had done?
I don't remember.
You don't remember?
I don't remember.
Could he have said something like that?
Objection calls for speculation.
Overruled.
Could you read it again?
Yes. Did your brother in your presence state that he didn't want anyone looking over his shoulder and controlling him, and that's why he murdered his parents to begin with? And this made him very unhappy that someone else knew about it.
Objection contrary.
Overruled.
No,
Or that.
that
You
wasn't.
cannot reread the same question to me.
That's true. He did not.
In,
Your next
in-
question,
In
please.
summary, do you remember him making any statements regarding your father controlling him, and that's why he murdered him?
Ask him.
Overruled.
No, Lyle was certainly not talking to Dr. Oziel about reasons why he didn't even want to. He didn't even admit to Dr. Oziel that he killed our parents. He said he didn't want to talk about it. And he didn't want to be there.
Was it clear from your brother's reaction, getting mad at you for telling Dr. Oziel that he in fact was involved in the killing of your parents?
Objection calls for speculation.
Sustained.
Did he in fact express his anger in Dr. Oziel's presence with you for having told what you and he had done?
Ask him answer.
Sustained.
Did Dr. Oziel in your presence state that he felt that your brother was menacing?
He may have. I don't remember.
There's some things you don't remember that you told to Dr. Oziel that day, I take it.
I'm sure there's a lot of things I don't remember. I just remember what I remember.
So some of these things that, for example, the BBC movie, you may have said.
Well, there's certain things I know I wouldn't have said, but I can't say that I definitely didn't because I don't remember, but I'm sure that I would not have said it.
At some point, did you get the feeling that your brother wanted to get rid of Dr. Oziel?
Did he say that to me?
No, at some point, did you feel that your brother wanted to get rid of Dr. Oziel?
Objection on.
Overruled.
No.
At some point, did you run out of the office?
Yes.
Why?
Because of two reasons. One, Lyle's reaction, and I couldn't stand it anymore. I felt I was now feeling even more guilty. I was now feeling guilty about the fact that I thought I had displeased my brother and betrayed him, and I now thought the whole world was a mess and things were just getting worse by the second. I just ran out. I couldn't take it anymore.
So you had discussed with Dr. Oziel what you and he had done with respect to killing your parents. And when he came in and he was angry with you, you realized that, as I think you testified, you had screwed up. Correct?
I'm sorry. You said too many things in there.
Okay. After telling you told Dr. Oziel what you and your brother had done with respect to killing your parents, correct?
I told him that we had killed our parents.
And you gave him details of that, correct?
No,
As
I
you've
asked him to
indicated.
answer.
Sustained.
You also have testified that your brother came in and was angry with you for having disclosed what you and he had done to your parents.
Objection.
Correct.
Cumulative.
He didn't know. He didn't know exactly what I disclosed to Dr. Oziel. No one told him.
He knew that you had implicated him in the murders.
Objection, Your Honor, calls for speculation.
Sustained. Sustained.
What is it that you knew at that point?
Your Honor, I'm going to object to this. because we're getting-
Objection sustained. It's already been asked. Mr. Friano, go on something else, please.
At some point, you left the room,
Yes, I did.
and you left the room because your brother was angry at you.
Objection, asked and answered.
Overruled.
I left the room for a multitude of reasons, just all sorts of guilty feelings. So I just ran out.
Was one of those guilty feelings the fact that now your brother knew that you had disclosed what you and he had done?
Objection, Your Honor, asked and answered.
Overruled.
Yes,
And where did you go after that?
I ran downstairs to the car.
And was your new Jeep sitting down at the street?
Yes, it was.
And did your brother come down shortly thereafter?
Yes, he did.
Did you have a conversation with your brother at the Jeep?
With Dr. Oziel and Lyle. They both came down together. And yes, we did at that point.
And at that point, did you tell Dr. Oziel that you would be back, or did you call him the next day?
I'm sorry, I didn't hear it.
At that point, at your Jeep, did you discuss with Dr. Oziel another session, or did you call him later?
No, we discussed coming back. I don't remember if we made the exact time, but we discussed coming back on the Thursday.
Now, you have testified in direct examination that you felt that you better go back because Dr. Oziel might go to the police.
That's what Lyle and I discussed later.
So was it sometime later that you made the decision to go back to talk to Dr. Oziel more?
No, we had made the plans with Dr. Oziel. We discussed later whether or not we were going to cancel them or whether or not we were going to keep those plans.
And you decided it was a good idea to keep the plans because he now had information that he could turn over to the police, you thought?
Well, he definitely had information that he could turn over to the police.
And you didn't want that to happen.
No.
Now, on November 2nd, you and your brother both went in to see Dr. Oziel, is that correct?
Yes, we did.
And on that day, was there a discussion about why you had killed your parents?
No, there wasn't.
At any time during that entire session on November 2nd, did you and your brother ever discuss the killing of your parents?
Yeah, Dr. Oziel kept bringing it up. And he would either, I don't think he directly came out and asked why, but he certainly was telling us the reasons. Part of the session was based on that point, him telling us what we knew of the family and we discussing what we knew of the family, and then him telling us how that fit into why. But the basic, I would say, premise of the conversation was Dr. Oziel telling me that I didn't know why.
Mr. Menendez, are you telling these jurors that you and your brother went into that session and you simply sat back passively and said, why don't you guess why we did this?
No, actually, Lyle told him up front that he did not want to discuss why, and that's not why he was there. And so we all decided that we would talk about what he called I think he called it the constellation of our family and how it was put together and what the elements were in it.
Early on in the conversation, did Dr. Oziel inform you and your brother that he had taped the session and that he had instructed his attorney that upon his demise that the attorney would go to the police and that this tape was in a safety deposit box?
That's if I remember correctly, that's the first thing he said, which put us back a little. That's the first thing he said, that he had these tapes in safety deposit boxes.
And did he inform you at that time, you and your brother, that that was for his protection?
Yes.
that he felt threatened by you?
Yes.
At that point, isn't it true that your brother proceeded to laugh and he told Dr. Oziel that he should have felt threatened because after the session, he and you had sat in your Jeep and the first statement that he made to you was, well, now how do we kill Oziel?
Definitely not.
Your brother was angry that day, was he? Was he not on August? On
Which day are
October,
you talking about?
October 31st, 1989. He was angry that day, wasn't he?
Yes, he was.
And he was angry because somebody else knew what you and he had done.
That's part of it, but he was more angry at the break of loyalty. And I'm not sure if it was just pure anger. I think he was quite hurt.
He was angry at you for disclosing and also angry that there was someone else that knew. Would that be fair to say?
That would be fair to say that was part of what was happening. I think that another large part was that he felt a serious break in loyalty, that I would go to someone else, and he felt hurt about that. He liked how close our relationship was.
So there are two reasons.
2 reasons that I knew about.
Okay. One being that he was angry that there was a third party that knew.
Objection or asked and answered.
Sustain.
Did he explain to Dr. Oziel that you and he had discussed killing Dr. Oziel?
Did he explain that?
Yes.
No.
After Dr. Oziel had explained to you and your brother that he had this tape in a safety deposit box, this insurance policy, was it
Performing question.
Sustain.
after Dr. Oziel told you and your brother that he had this tape, that he had it in a safety deposit box, did your brother joke with him about then having to protect Dr. Oziel so that nothing would happen to him and the tapes being released?
I recognize that. I don't know where it was brought up. I don't have a recollection of it being brought up right after that. But I recognize that statement.
Did your brother tell Dr. Oziel that he had decided that it wouldn't look too good if Dr. Oziel disappeared too soon because it would have been too close to when your parents had been killed?
No, you're missing the whole point of what I'm saying. Dr. Oziel was telling us that he felt threatened, and because of it, he could go to the police right then if he wanted to. And we were trying to tell him no reason to feel threatened. Nothing's gonna happen. And I wouldn't have said something like that.
When you were joking around after he had told you about this tape, that's when the joking occurred about, well, it wouldn't look too good if you disappeared too soon. Isn't that correct?
After he had told us about the tape, we were certainly not in a joking mood.
Mr. Menendez, you said that from the very beginning, you thought that you were going to get caught. Isn't that right?
Asked and answered.
Sustain.
Mr. Menendez, do you recall stating on November 29th, 1989, that I've known from the beginning, no clues, no one heard anything?
Object, Counselor Harrison.
Sustain.
This is a statement that you made, sir.
No, I'm going to
Same
object.
objection.
All right, sustained at this time. Go on to something else, please.
Very well. Mr. Menendez, were you present when Dr. Oziel had the conversation with your brother and wherein Dr. Oziel said, I don't want to live in fear?
Objection, Your Honor. Vegas time and place.
Overruled.
No, I don't remember that.
On November 2nd, 1989, in that session that you had with your brother, with Dr. Oziel?
Dr. Oziel said he didn't want to live in fear?
Yes.
I don't remember it.
Dr. Oziel had expressed that he was afraid, correct?
He said that he was afraid on the 31st. I guess he still said that he was afraid, yeah.
And that when Dr. Oziel said, I don't want to live in fear, your brother said, neither did my father. You remember that?
No.
At that point, was there a discussion about why you had wanted to kill your father?
At some point in the conversation, my father's personality was deeply discussed.
And you expressed those things that you didn't like about your father? That'd be fair to say?
No, that wouldn't be fair to say.
You're telling what a good guy your father was.
No, I was telling Dr. Oziel at the same time that I wanted to write a book about all the great things that my father had been. And I was also telling him some of the other things. He was telling me some of the things. It was sort of like a group conversation about what he knew about my dad and about how we wanted to write a book and some of the things that we knew about our dad.
When he wanted to know from you, why did you kill your mother? What did you tell him?
Objection, since that's not
Overruled.
I didn't tell him. I remember specifically that Lyle said that he was not going to discuss that.
Are you saying that when Dr. Oziel asked about why you killed your mother, your brother said, no, we're not going to discuss motivation here?
I believe Dr. Oziel testified to that.
I believe Dr. Oziel testified that you and your brother had discussed why you killed your mother.
Objection, Your Honor.
Isn't that correct?
Argumentative.
Objection sustained. Rephrase the question.
Yes, Your Honor. Isn't it true that Dr. Oziel testified here as to what you and your brother told him with regard to why you killed your mother as well?
Yes, he said some things along that line as well.
And he said he had testified that the plot began with the viewing of this BBC special, correct?
Objection, what Dr. Oziel testified to, Your Honor, is irrelevant.
Overruled.
Yes, Dr. Oziel testified to that here.
And that the father in that BBC special mirrored what you and your brother wanted to do to your father. Isn't that correct?
That misstates the testimony.
Overruled.
Yeah, he said something along those lines as well.
Now, you have indicated that you were a friend of Brian Islamania.
Yes.
And in this movie,
All right, let's go on to something else.
this is reserved for
Let's just
later.
go on to something else.
You had indicated that your mother was depressed and suicidal. Is that correct?
Yeah, that was
Yeah.
talked about.
You expressed that she would potentially be a witness against you.
No, I'm not sure what context you're talking about.
Well, if you had killed your father and your mother would have lived, would she have been a witness against you?
Your Honor, I object that this confusion is talking about what was said about Dr. Oziel.
Why don't you rephrase the question,
Okay.
please?
Is your was your state of mind at the time,
Which,
that at the time of the killings, that if your mother had lived, she could have been a witness against you?
Objection, Your Honor, calls for speculation.
overruled.
No, I doubt she would have been a witness against us at any point. I think that she might very well have killed us and killed herself, just poisoned everyone. But I doubt very much that she would come to court and testify against us. That wouldn't have happened.
That's your state of mind.
That's more than my state of mind. That's my absolute belief.
You wanted to kill your mother just as badly as you wanted to kill your father?
I hadn't thought about the difference. I only thought that they were going to kill us, and at that last moment, to kill them.
Did you ever tell Dr. Oziel that as it got closer to the time when you would kill your parents, that there were second thoughts about killing your mother?
No, we didn't discuss it. We didn't discuss that. Let me try to remember exactly. I know we didn't discuss that. I don't remember certain things.
Do you remember telling Dr. Oziel that once you had made the plan and had formed it with
We're
your
not
brother?
going to object to this nasty approach.
All right. Or represented, the jury panel is not present at the moment. There was some matter that council wanted to discuss at the break, and what is that?
Well, Mr. Korean indicated he's not going to pursue that particular line of questioning, and he's designated only 2 areas with respect to Dr. Oziel's notes that he wanted to question Mr. Menendez about. And one of those areas appears on page 12 of the notes, which has to do with my client telling him about the mother locking the doors. And I would object to that because he's already asked that and it's been answered already in his cross-examination. The other area he designated is on page 19 of the notes, the middle paragraph. And my concern is that the notes don't accurately reflect what Dr. Oziel testified to concerning this discussion, which was Erik recounted his father's near disinheritance of him over the fact that he didn't like the way Erik was treating him recently as further evidence of the need to get rid of the father. And what Dr. Oziel actually testified to in this for, if I can find it. Was that in the context of how impossible the father was, he brought up the example of his near disinheritance over a minor matter as what contributed to or possibly led up to the killing of the father. And so my only objection to that is that these inheritance, it appeared on page 9371 and 9372 of the transcript. This is Dr. Oziel's direct. And he said, in the context of talking about how impossible the father was, Erik also recounted his father's near disinheritance of him as an example of one of the things that led to, or an example of, why they had to kill their father. And all I'm saying is that what should be referred to with the witness is what Dr. Oziel actually testified to, and not what he wrote in the notes.
As we discussed yesterday, the prosecution or any lawyer in cross-examining a witness can phrase the question in a way that the cross-examiner chooses, and it need not quote verbatim prior testimony, as long as it's phrased in the context of a question and not a quotation. And whether he asks that in cross-examination in the context of the exact quote, or whether he asks it in just the nature of a question, that will be the decision made by the cross-examiner. If there is reference to the notes, then that would not be an appropriate way of doing it, since the testimony of the witness is before the trier of fact, not the notes. So if you're going to quote anything, then you should be quoting the actual transcript of Oziel's testimony, but certainly you can paraphrase and ask questions in other ways without quoting it. And in doing so, I have already indicated you can refer to what is said in the notes without referring to that as a source, so that you can obtain answers from the witness. there's no reason to believe that the witness's testimony will conform with what Dr. Oziel testified in court versus what he said in his notes. So we'll have that resolved by the questioning of the witness and his answers. All right, well, that's up to him as far as how he wants to proceed. But as far as the repetitive nature of the examination, Mr. Kuriyama, let's see if we can avoid that. There's certainly a permissible scope of that during cross-examination, but you are getting in certain areas to repetitive questioning that is unduly time-consuming. So let's see if we can speed it up a little bit.
I believe that I can finish before both juries, before lunchtime.
Before the dual jury.
I'm ready to go.
All right, just to follow up on one matter that was a subject of some objections during the testimony this morning. There were references to the November the 29th conversation that transpired between, that occurred between the defendant, Erik Menendez, and Craig Signorelli. And that is an area that the court had indicated and the people had indicated would be reserved for the testimony before the Erik Menendez jury only, and the court will confine that to that jury only, since although it's a tape recorded conversation, the entirety of it won't come before the jury, and to take it out of context then puts Signorelli's credibility to some extent at issue here, and only the Erik Menendez jury has had an opportunity to evaluate his credibility. So for that purpose, the examination regarding the November 29th conversation should occur only before the Erik Menendez jury.
I have a quick question on scheduling.
Yes.
I seem to have contracted the flu bug that Mr. Kuriyama had, and so.
That was
I want-
Mr. Kuriyama's son who gave it to him, who's
Right.
given it to you.
Right. And
It's
so-
directly down council table.
Right. So what I was going to ask is, are there any other witnesses this afternoon aside from, are there going to be other witnesses called this afternoon aside from Mr.
I
Menendez?
believe Mr. Kuriyama's going to finish
Well-
until the end of the day.
If you were to finish early, are there going to be other witnesses? Because I was going to propose that I go home at lunch, since this is all going to be this afternoon in front of the Erik Menendez jury only.
Well, is the redirect going to consume some time as well?
Sometime, not large enough.
Well, is it, how long is your cross before the one jury going to take?
I think I could finish by the end of the day.
All right, well, if that is true, then it appears that there won't be any other witnesses today other than Erik Menendez.
Permission, and may I be excused to that?
That's up to you. If you want to leave, then certainly you can. As far as tomorrow, then, assuming we finish with this witness today, who is scheduled for tomorrow? I noticed that Ms. Lansing was working on her witness list there during the cross-examination.
The ever-changing witness list. We have tentatively scheduled for tomorrow, Andy Cano, Marta Cano, Dave Maravich, Tracy Baker, and Donovan Goudreau.
Okay, and would that be a sufficient number of witnesses to consume the whole day?
I believe so.
All right, are there any in limine matters that have to be resolved in regards to them?
I believe so. As to market, do you want to do that now, or do you want me to just?
No, I just want to know if there are such.
There will be, so I think that will be sufficient witnesses with the 402s.
All right. Are we ready then with the juries?
Yes, sir.
Okay, let's get the jury panels in, please. The cross-examination.
Mr. Menendez, with respect to the October 31st, 1989 session, did you tell Dr. Oziel that you remembered that your mother locked the doors to the bedroom? I'll rephrase that, Your Honor. On the November 2nd, 1989 session, or in that session, did you tell Dr. Oziel that your mother had locked the doors to the bedroom, and that your mother and father had sensed that that you were capable of murdering them?
No. I said something like that, but I didn't say that.
Now, on that same November 2nd session, in the context of talking about how impossible your father was, did you tell Dr. Oziel that your father had nearly disinherited had nearly disinherited you.
No,
And that was another example of why you had to kill your father?
no, I wouldn't have used the word disinherit since he didn't nearly disinherited me. He did. But we did talk about what my dad was like and the things that he would do over my lifetime.
In fact, sir, he did not disinherit you, did he?
Apparently not.
In fact, the will that was found gave his estate to you and your brother.
Yes.
Had he discussed disinheritance with you before?
Dr. Oziel or
No,
my
your father.
We didn't discuss it. He told me. My dad rarely discussed things with me.
Did he ever say, if you don't shape up, I'm going to disinherit you?
No, he didn't use disinheriting me as a threat hanging over my head. I either was or I wasn't.
It was, I believe you stated September of 1988 that your father had the discussion about disinheriting you.
Yes, he told me I was out of the will.
Now, with regard to the will, you had discussed that your father had brought a computer home when you were about 14 or 15 years old.
I really don't remember the date. I was 13, 14, not 15. It may have been.
Do you remember?
I would object to this, for this point in examination, because the rest of my, this will go through.
Well, I don't know exactly where he's going yet, so objection overruled as to that question.
With respect to this will and your knowledge, strike that. With respect to the computer that your father brought home and your knowledge about computers, do you know if the computer your father brought home was an IBM or an Apple? Do you know what type of computer it was?
I don't remember. I know it was a big, bulky, big thing that even had a telephone thing attached to it, which is what I like to play with.
And in fact, you actually operated this computer.
I actually, by accident, erased the hard disk and was banned from using the computer at that point. But I used to like to play the video games on it.
Did your parents give you lessons on how to operate a computer after that, so you wouldn't do that again?
No. Before that, they had a big manual, a DOS manual, and a basic manual. It was just boxes of manuals how to use this computer, but I never read those, which is why I made that mistake.
Never opened one of those up?
I don't remember opening. I was so young, I didn't want to read all this material. I just wanted to play around with it.
And you say there was a phone on this computer?
Yeah, it was a. You could call people through this computer. I remember that, and I was always trying to access those things, and I could never figure it out.
Was there more than one computer at the Beverly Hills mansion when your parents were killed?
Yes, I believe there were two.
One was upstairs in the bedroom.
One was my mother's, and one was, I think it was in the study.
And whose was that?
It was a computer that was used for homework assignments and things like that.
By whom?
By my mother, and by, I guess, I used it once to type up a paper once I learned how to type in school.
Did you ever see your brother operate that computer?
No, I didn't. He wasn't a computer person.
Now, you're talking about this phone on the computer. Was that computer then wasn't at your house when you killed your parents? The one that you were talking about that your father brought home in your early teens?
I really, I don't know. I don't remember.
Did you ever see a computer in your brother's guest house?
No.
Now, you had indicated that there was a phone in your brother's guest house, correct?
Yes.
Was that a stationary phone, or was it one of those mobile type phones that you could pick up and take with you if you had to go to the bathroom or something like that?
You mean, was it a portable,
Yes.
or did it have a long cord?
Right.
I don't know. I don't know.
Do you remember ever using the phone in the guest house?
No, I don't.
You have testified that you believed that you were a suspect in September of 1989, correct?
Yes.
And that you went to talk to Dr. Oziel on October 31st?
Yes.
About a week before you went to talk to Dr. Oziel, that is on October 24th, did you have a conversation with Detective Zoller?
Yeah, at my house.
And did Detective Zoller indicate to you that there was going to be an LA Times article about the participation, perhaps, of your brother in the killings?
Yes.
Did that concern you?
Certainly.
And did you take steps in that regard?
I remember trying to locate my brother. I don't remember if I ever did.
So this occurred about a week before you actually went to see Dr. Oziel?
I don't remember it recurring a week before, but if it was on the 24th and I went to see Oziel on the 31st, then it would be a week.
Did that have an effect on you, your state of mind?
In terms of me thinking that the police had me as a suspect,
Right.
I had known that since September.
But did that heighten your concern about that?
No, actually it didn't. It was surprising to me that if the police suspected me, they were telling me that someone else suspected me. It was a little confusing, but I still suspected that the police thought I was involved.
Now, you had a relationship with Dr. Oziel prior to seeing him on October 31st and November 2nd?
Objection.
Overall.
Yes.
Correct. And in fact, you had an appointment with him on August 18th, 1989, correct?
Yes, I did.
And that was a day that you and your brother went down to San Diego to buy the shotguns?
Yeah, I had canceled that appointment earlier in the week.
Okay.
I had made it and then canceled it.
When is it your recollection that you canceled that?
I know it was after I spoke to my brother because I had made it before I spoke to my brother.
What day would that have been on?
I made it after the conversation with my father on Sunday when he told me that I was going to be having to sleep at home some days, and I just wanted to die, and so I called to make an appointment because I hadn't seen him in a long time. And then after I talked to Lyle and told him everything, there was no need to go to Dr. Oziel, so I canceled it.
Dr. Oziel was a friend of yours at that point, correct?
Objection, Your Honor.
Overall.
No, not really.
Not really.
No, he was a therapist who he was a therapist.
And if you were having any problems at that time, you would have gone to see him on August 18th.
Not really. I know that he's.
Your Honor, I'm going to object to the questions in this matter.
Overall.
I know that he spoke with my parents, and so I was. I never really told him much about.
Your Honor, I'd like to be heard.
All right, you may.
Mr. Menendez, take you back to the night of the killings. You had testified that you and your brother had gone to the Century 14, and I believe we didn't get beyond that. So after the Century 14 theater, where did you next go?
Up to Mulholland Drive or Mulholland Highway.
Were you directing your brother where to go at this point?
At that point, yes.
You were familiar with the area.
Yes, I was.
Where exactly did you direct your brother to stop that night?
On Mulholland Highway.
Where, though?
Oh, I don't know. Within 1 to 2 miles of cold water. It was dark. He just pulled over at the side of the road.
Was it pitch black outside that you could barely see anything?
I know that it was like late at night. I don't remember what kind of moon was out that night.
It's your recollection that you went about 2 miles and then you told your brother to stop. This looks like a good place to dump the guns.
No, I don't know if I told him. I don't remember telling him where to dump the guns. I remember directing him how to get to Mulholland Drive or Highway, but I don't really remember how far down we went or me telling him where to stop.
Was there some discussion, though, in the car as to your knowledge of the area and where you would end up throwing the shotguns?
Yeah, I kept saying we needed to get rid of the guns and or something to that extent. And I didn't know where, so I just said, drive up to Mulholland.
Okay, and at some point, I believe after 2 miles, was it, that you said, Okay, stop here.
Overall.
No, I didn't tell him how far down Mulholland, and I don't know exactly how far down we went. But I don't remember telling him where to stop.
Do you remember houses being around where you took the guns down this hill?
No.
Do you remember any lights from any buildings around there?
No, I remember a lot of forest.
When you went down the hill, was it dirt or was it bush or what?
Was dirt, bush, trees, all kinds of things.
And how far did you take the guns down?
It didn't seem that far to me. I don't know, 50 feet? Maybe 75. I don't know. I ran down so quickly and ran back up.
Did you tell Dr. Oziel that you went down about 150 feet?
I didn't tell him how far I went down.
You just told him that you went down a hill?
Yeah.
Had you, over the 7 months that you were out on the streets, did you ever try to go back to recover those guns?
No, I didn't.
Did you ever have anybody try to find those guns for you?
No.
Did you ever discuss with your brother an intent to get those guns somehow?
In the session with Dr. Oziel, we discussed it.
So it's your understanding that neither you or, to your knowledge, your brother never tried to get the guns?
Overall.
I don't know what Lyle tried to do, but I know we discussed it with Dr. Oziel.
And when you discussed it with Dr. Oziel, was there then an attempt to get the guns?
No.
And after you went down the side of this hill and I believe you said you put some bushes or some branches over the guns?
I don't really remember whatever was around. I just tried it with like 2 sweeps. I didn't cover the guns completely.
And then you ran up the hill,
Yes.
got into your car,
Yes.
and your brother was driving.
Yes.
Was he facing the same direction as when you were going?
I don't remember. I don't remember.
And where'd you go after that?
Well, we wanted to try to get over to Perry and at the Taste of LA. So I was telling him, Lyle was unfamiliar with the area, much less familiar than I was. So I was telling him how to get to Taste of LA.
Was he kind of driving erratically at that point?
He was driving fast, and I was telling him to slow down because I was afraid that we'd get pulled over and arrested and all this stuff in the car, and that we were going to get arrested right then.
You had testified on direct that you had to, at one point, tell your brother to get it together.
Yes.
And as you're coming down this hill, did you tell him how to get to the Santa Monica Civic Center?
I mean, when I was coming down Mulholland,
Yes.
yeah, I was giving him directions.
And you knew how to get to Santa Monica from that point?
Yes.
And was it your understanding that the Santa Monica Civic Center was on, what, 3rd Street, between 3rd and 4th Street in Santa Monica?
There's Lincoln, 3rd, 4th. You can take any of them, I believe.
And on the way to the Santa Monica Civic, did you stop anywhere?
We may very well have stopped at the gas station on the way there. I don't have a specific memory of doing that before, but that very well may have happened.
Where did you tell him? Which route did you tell him to take?
The freeway.
From Mulholland to where?
Mulholland to, it was one of the streets that went to the 405. It was either Santa Monica or Sunset. I don't remember which one.
And then on to the 405.
Yeah, the 405 just cuts into the 10, which brings you right into Santa Monica.
And where was it that you stopped at this gas station, sir?
in Santa Monica.
Was it very close to the Santa Monica Civic?
The Santa Monica Civic, we got lost we took a wrong street somewhere right in Santa Monica getting to the Civic Center because I wasn't exactly sure on what street that place was, but I know the gas station was real close to it.
Close to where the Taste of LA was.
Yeah, I believe so. I believe it was right off the freeway, the gas station.
And was the gas station open?
I think so.
Okay, and did you go to the back of this gas station?
Far to the side, I have a memory of some sort of a car wash there. I could be wrong, but it was far away from the gas station. There was a dumpster.
And at that point, you removed your pants?
Yes.
And did you see your brother remove anything?
I have a specific memory of his shoes. I don't remember if he took anything else off.
At that point, did he ask you, do you have some shoes I could wear? I got blood on mine.
I don't remember. I lived halfway in my car, so I if he did, I would have given him some.
And you had plenty of clothes to put on that day.
Yes.
And you pulled out another pair of pants,
Yes.
put those on.
Yes.
And then you went to the Santa Monica Civic Auditorium.
Yes.
And you went inside of the building?
No, I didn't go in at first. It wasn't a building. It was a fenced area of. I'm not even quite sure what exactly it was, but it was called the Taste of LA. I went in after Lyle didn't come out for a while. Lyle didn't want me to go in.
Was there a reason for that?
Yeah, my demeanor wasn't doing so well. He wanted me to just stay in the car and relax there. When he went to go find Perry.
And he went around and looked for Perry on the grounds.
I assume. I don't know. I wasn't with him.
Were you with him when he made a phone call to Perry?
No, I wasn't.
Did your brother tell you that he told Perry that you and he were there since 10:15, and he told Perry that?
I don't know what he told Perry. The one thing I remember is him saying that we were supposed to meet Perry at the Cheesecake Factory.
And did he tell you what the purpose of that was?
Yeah, he wanted to be with someone that night. I assume to try to further an alibi to try to. We hadn't met anyone that night, so I assume that was the reason.
Mr. Menendez, you say that you had been molested for 12 years, correct? That's your testimony?
Yes, that's what happened.
All the way up to when you were nearly 19 years old?
Up until my father died.
Now, are there any witnesses to this molestation?
Was anyone in the room?
Yes.
No.
In fact, the only person that could deny or contest your claim is your father, correct?
My father and my mother.
And both of them are dead, correct?
Yes.
At this point, Your Honor, with respect to that
All right, let
one
me see
issue.
counsel at the sidebar regarding the schedule here. The attorneys have a little conference that they want to engage in before the completion of this portion of the examination, just to give the juries an idea of what's happening today or this afternoon. There'll be a little bit more of cross-examination before both juries, and then some redirect examination by counsel for the defendant before both juries. And then, and that'll happen this afternoon. And then as soon as that's completed, the gold jury will be excused for the rest of the day, and then we'll have some other examination where the blue jury will remain. And then we'll have both juries back tomorrow morning. But we need you both back this afternoon. But before we complete this, there's a need for some conference. And then, so we'll take our recess for the lunch hour now and have both juries back at 1:30. And when we're finished with the examination before both juries, then the gold jury will be excused until tomorrow. So you won't be here all afternoon, but the blue jury will. All right, we'll see you all back here at 1:30. Don't discuss the matter with anyone. Don't form any final opinions about it. We'll see you all back here at 1:30. Trial, we have the trial participants and both juries in court. And a few moments ago, Mr. Kuriyama indicated to me that he had been ill during the lunch hour with flu, and from what he has indicated to me and how he has described his condition, it's quite clear that he is very ill and is running a fever at this point. And combined with the fact that his co-prosecutor had to leave this morning for the same reason, pretty soon that end of the table is going to get rather empty. And unfortunately, he's unable to continue this afternoon. It's unfortunate for all of us, but those things do happen. And I apologize. Had we been able to deal with it some other way, we would. But the only way we can deal with it at this point is to recess and hope that he's better tomorrow and that we can complete the examination of the witness who's on the witness stand and then proceed with the next witnesses in the trial. It's one of those things that occurs during the course of the trial. We've experienced it before, and it's unfortunate, but not much we can do about it. There are certain participants in the trial that we can't do without, and you know who they are. So what we have to do is hope for the best and hope for tomorrow we can continue. So I'll excuse you now and ask that you return tomorrow at 9 o'clock, at which time, hopefully, when everyone is here, we'll be able to resume with the trial. Don't discuss this case with anyone. Don't form any opinions about it. And we'll see you all back here tomorrow at 9 o'clock. Trial participants, and the reason for the delay this morning has been discussions between the court and counsel in regards to Mr. Kuriyama's health. He was here this morning. Gamely, he came in, but he's been spending more time in another room other than the courtroom because of his condition. And he is very ill and running a fever. And it's just a situation where not only is it impossible for him to continue because of his condition, but also it's a potential situation where others can catch what he's suffering from. So rather than to run that risk and to create other problems, I've indicated that, and he's indicated to me he cannot continue today. And because of that, we'll honor that situation. And hopefully tomorrow he'll be in a position to continue, and we'll proceed with testimony, finish off the testimony that we're hearing. I'd like to give you a guarantee that he'll be able to do it tomorrow, but the best we can do is hope that he will be, and hope that we can proceed tomorrow with that phase of the testimony. We are, the lawyers and I are going to spend some time today dealing with other matters that we otherwise would have to deal with anyway outside of your presence. So we'll be doing some work here, and I'll let you go for the balance of the day. I'm sorry that you came in today, but we're hopeful that he would be able to proceed, and just didn't work out. So we'll excuse you and ask that you all return tomorrow at 10 o'clock tomorrow morning, 10 o'clock. Don't discuss this case among yourselves or with anyone else, and we'll resume tomorrow at 10 o'clock. Also, don't form any opinions about this case until it's finally given to you for a decision. We'll see you all back here tomorrow at 10 o'clock. Do counsel have that other document for me to look at, or you said there was 11 or 13 page? All right, if you have something, you can just give it to the clerk. Okay, I'll review that other document. The jury panels are not present. Matter is here to discuss some issues relating to testimony of other witnesses who might be called by the defense. Do the parties have any preference as to which witness to discuss first? Well, then which one do you want to discuss first?
Why don't we start with Tracy Baker?
All right. What is it in this report of February the 25th, 1993 that the defense seeks to offer.
There are four main things that the state can testify to, one of which is the incident in which she's having dinner at the Menendez home, and Mr. Menendez inexplicably gets up from the table once Mrs. Menendez.
All right, I've read that. Is that something that is or has been or will be referred to in the testimony of either defendant, an incident that they were recipient to?
Well, they talk about the fact that they were I think Mr. Wåho Menendez has testified to the fact.
No, I'm talking about this specific incident.
He's testified that there were a number of occasions.
Has anybody described this incident? Because this lady doesn't know what actually happened. She has seen little bits of it. And
This is corroborative of one of the times that Mr. Wåho Menendez has indicated that this behavior occurred.
well, it would be if,
Anybody has specific dates of when it occurred, but this is clearly one that she is there. Didn't have him testify to the specific one, but clearly, the objection that it would be cumulative, it's clearly corroborative of behavior that he has described.
that if Lyle Menendez had described this, that there had been a cumulative objection.
He's described it happened on a number of occasions. He certainly hasn't described specific dates, but it's exactly the same behavior that he has described. If the court wants, we can certainly testify that it was there at this particular time. I just had him describe the incidents generally that happened on a number of occasions, not the specific one, but if we need that for a foundation, he can certainly do that.
Well, she has no clear recollection of exactly what was said or anything else. And if there was something here that occurred and she is an independent or a separate witness to it, then perhaps it would be. But the way it's described here, it doesn't sound like she really saw what it is that the defense is seeking to prove.
She saw behavior.
I know what she's described as seeing, but it is ambiguous at best. And if it has any probative value, it would only relate to what it is that the defendant's state of mind was and what precisely they say occurred. If you had her testimony standing by itself, it wouldn't mean a thing. It would be totally ambiguous. So you'd need a description, if there is one, from one of the defendants as to what happened on this occasion, if they're capable of doing so. And then this would be the corroboration that the event occurred. But by itself, all right, so if there is evidence introduced by one of the defendants in his testimony about this particular incident, then my ruling would be that this would be corroborative of that and would be admissible, her observations of it. All right, what's the other area?
One of the areas would be her witnessing the threat by Mr. Menendez to Craig Signorelli, the threat to kill him, which
All right.
took place in front of both Erik and Wåho Menendez and a number of other witnesses.
And did people wish to be heard on that?
No, Your Honor, as to that, I think that there has been testimony about this incident. I should only point out that we are going to call Mr. Fenno in rebuttal, and I'm sure he'll be asked about that. So to that extent, it could be cumulative, but.
Will you be asking that? If the prosecution asks him about it, it's not cumulative.
I'm sure.
Well, regardless of it, it's been discussed in other testimony. And since there is other witnesses other than the defendants to this incident, it is corroborative of the defendant's testimony, so it would be admissible.
The third area we intended to go into was her presence at the Thanksgiving dinner, particularly with regard to the statement which she attributes to Mr. Wåho Menendez when he says grace before the meal and then indicates that he's hoping that his family will welcome her into the family, that they will like her as much as he does so that she can be a friend of his, which I think is corroborative of his testimony. The same type of behavior with regard to Mr. Goudreau, which was that there was no possibility of having someone who could be a friend and who could be a part of the family unless they were accepted by the family.
I don't see that as probative of that at all. It just seems to be extraneous, irrelevant evidence that of an incident at a dinner table.
Well, it's our position that it's corroborative of the state of mind of Menendez with regard to the need to have people accepted by the family, so that he could have a friendship with them, which testified to at some length with regard to Donovan the girl, and I think this is another example.
All right, is there an objection by the prosecution to this?
Yes, there is, Your Honor. I think it's basically there to create sympathy for the defendant, that he would say grace, and I think that it's self-serving hearsay as well.
It's, regardless of whether it's hearsay, it's irrelevant, doesn't meet the proof that the defense offers here. It doesn't prove what the defense intends it to prove. It is not probative of any issue in dispute in this case, and is irrelevant and cumulative of other evidence that might relate to the same sort of information, even if it was relevant. So the objection would be sustained. Also under 352 of the evidence code.
If the district attorney's objection is with regard to the fact that he said grace before the meal and that would be somehow prejudicial, that's not the part of the statement that we were concerned about. We were more concerned about his expression of his desire and need to have his family accept her into the family.
I don't see that that is proved by the content of this document, and is not relevant, and under 352 of the evidence code, its any probative value is substantially outweighed by its potential prejudice, and it does seem to be something inclined to just generate sympathy and doesn't prove anything.
The fourth area that we wanted, and last area we wanted to elicit from this witness was the behavior of Kitty Menendez toward her with regard to questioning her about the nature of her relationship with her son, Wåho Menendez, how intimate they had been, her behavior toward Tracy with regard to the nature of the relationship, the questioning, the indicating that Wåho didn't have time for her, the physical assault on Tracy Baker by Kitty Menendez, and telling her that Wåho didn't have any time to see her, and that the one time Tracy called after that, spoke to Kitty Menendez and was not permitted even to speak to Jose, which is this incident takes place in the fall of 1988, which is a demonstration of a number of things. One is the continued control by the family over Wåho Menendez, despite the fact he's almost 21 at this time. The assaultive behavior of Kitty Menendez, the over-intrusive nature, and the hyper-jealousy that she seemed to exhibit with regard to Wåho Menendez and his girlfriends.
People wish to be heard.
Yes, Your Honor, I think that this particular incident is inflammatory without being particularly probative. What preceded this, what was termed an assault by the defense, is the revelation by Ms. Baker that she had had sexual relations with Wåho Menendez and appears in the Menendez home. And I don't think it's all that unreasonable for a parent to be displeased by their children having sexual intercourse inside of the family home. I don't think that's a very unique reaction, but I think that given the state of the case, that it's inflammatory. And therefore, I don't think that it has probative value, such as to corroborate anything in dispute in this case.
All right, did you want to respond to that?
Yes, Your Honor. It's our position that it's up to the jury to decide whether this is appropriate behavior or outside the norm with regard to Kitty Menendez. They certainly were aware of some of the activities that their son was involved in terms of of Jamie, of the other girlfriend. And it is not only the fact that she's concerned that they had an intimate relationship that took place in the home, but the fact that she would interrogate her to the degree that she did, and asking her questions about where she thought the relationship was going, and that Wåho didn't have time for her and she wasn't appropriate, and to get to the point where she actually takes her by the shoulders and shoves her back down on the couch and puts her face right in Tracy Baker's face and confronts her in this way. I think it's highly corroborative of the testimony of both Wåho and Erik Menendez with regard to Kitty Menendez's behavior. We have independent people seeing that behavior earlier in their lives, but this is one of the few people who experienced it at this late date, that it was still going on, that she was still physically confrontational, that she was still controlling and interfering and insulting and demeaning. I don't think we have anybody else around this time period who has seen this behavior.
Well, My question is, number one, are there going to be other witnesses to testify about this sort of activity, specifically Mrs. Menendez inquiring of intimate details of the relationship of Lyle or Erik Menendez with females?
This is the only witness we were going to call.
You're not going to call Ms. Pisarcik or anybody else that have been referred to during the course of the trial as girlfriends or friends of the defendant?
That's correct.
We are gonna call a girlfriend of Erik Menendez, but his experience with girlfriends is different than Lyle, so it isn't for these purposes.
Is there going to be some expert testimony that's going to tie all this together, or is there something that you feel would, in good faith, be admissible evidence to connect all of this to some expert testimony?
Yes, I believe Dr. Conte will address this issue. He seemed to think that this particular incident was extremely important along with several others in terms of the unusual nature of the relationship between Mrs. Menendez and her son Lyle.
And somehow this played a role in the defendant's state of mind at the time he killed his parents?
Well, to the degree that all of the behavior by the parents becomes important. This is threatening behavior by the parent, which I think is admissible in any typical self-defense case.
Well, it's not threatening evidence.
Well, it's threatening behavior with regard to this one. She talks about being humiliated and terrified when she left the house that night as a result of this conduct by Kitty Menendez. I think it's corroborative of a number of things. One is her propensity for violence. Another is her over-involvement with regard to her son's life and his personal relationship.
Well, we've heard a lot of testimony about that. My question is that evidence that is going to be introduced by expert testimony that will relate to the defendant's state of mind at the time he killed his parents?
Yes, Your Honor.
Your Honor, comments?
Yes.
There's no indication here that Lyle Menendez was ever made aware of how his mother had behaved with Ms. Baker. And so unless he was aware, either by witnessing it or by being told about it, it seems that it would be irrelevant to his particular state of mind. It's kind of like whether, how the parents treat other people outside of the defendant's presence is not relevant to their state of mind.
And what is your response to that?
I believe that violent behavior by the victim in an assault case is always admissible.
Well, not all behavior of touching another human being is admissible. You just don't bring in every incident that has ever occurred in one's life and say it's admissible. And just to go back, and I've said this before, I'm not saying it as a basis for ruling on this because I haven't resolved the matter yet. But just because an expert says he thinks something is important or not does not necessarily make it independently admissible evidence, because you can't present to your experts everything that's ever happened in the lives of the defendants. And they can, I suppose, say that everything was important to them in forming their opinions. It doesn't make everything then admissible as independent evidence in the trial. Because that's the nature of expert testimony. They are hired to present a version of the events and a position, and they wouldn't be called unless they would be presenting that particular version of the events, and they present their evidence based upon what is presented to them.
I think that it becomes extremely important in two particular respects with regard to the experts are going to be asked, you got this information from the defendants, right? The defendants could have lied to you. It's all self-serving. And what do you have to rely on to show that this is reliable, that the information you receive from the defendant is reliable? And where they go is to outside sources for corroboration. And I think that this is in that the last few days of their lives, there are incidents of Kitty Menendez being physically assaulted toward Lyle Menendez, particularly with regard to the ripping off of the hairpiece. And the question is she the kind of person who it is believable that she would engage in this kind of physical confrontation with somebody? And here we have an incident less than a year before in which she takes a woman she's just barely met and shoves her back down on the couch, puts her face in her face, and interrogates and terrifies her. So I think that becomes extremely important in terms of believing whether Kitty Menendez is this kind of person. Secondly, the nature of the relationship with Wåho Menendez and his mother is one that they need to look to outside sources to see if what they're being told makes sense. And one of the things that corroborates the nature of the relationship is the extreme degree of jealousy that she exhibited. We've had people testify to her criticism of all three of the primary girlfriends in his life, Stacy, Jamie, and Christy. And it appears that it is just a pattern of behavior with regard to her to be extremely intrusive, extremely hostile to any other woman getting close to her son, which is corroborative of the information that Wåho Menendez has testified to with regard to what life was like with him, with his mother.
Your Honor, if I could be very briefly, just on another aspect of the expert testimony in this regard.
Yes.
The prosecution has intimated through questioning that these defendants were men at the time of the shootings, that they were grown, that they were adults, and there's the implication that they therefore had the freedom of movement and the independence of people of 18 and 21 raised in normal families. And one of the important factors in this case from an expert evaluation is how over-controlling and intrusive and involved both of these parents were in every aspect of their sons' lives, in other keeping their children infantile by staying involved in their lives, so that Lyle at 21 does not have the freedom of movement and the choices and the responsibilities and any of the other things that a normal 21-year-old has. Neither does Erik at 18. And the people obviously are going to argue, well, they were all grown up, they could have just left the house and gone away. And this kind of behavior by the mother, this demonstration of involvement in the most intimate side of their children's lives, corroborates what the defendants have been testifying to, which is how their parents controlled every aspect of their life, thus diminishing what in a normally developed person of their age would have been a sense of freedom, choices, and ability to extricate himself from the family. And that is a critical aspect of the testimony of all of our abuse experts on why abused children don't leave, and why in this situation it was particularly difficult for them to extricate themselves.
So your position is that this is corroborative of the defendant's subjective state of mind at the time of the killing?
It's corroborative of, it's corroborative, Your Honor, of their testimony about their parents' behaviors in controlling their lives. And corroborative of their, yes, in the sense of their feeling of lack of choices or alternatives.
Their subjective state of mind,
Right.
not the reasonable man's state of mind, but their personal state of mind.
Well, but it depends on whether or not, when faced with a threatening, oppressive, and controlling person, any reasonable person would react the same way. Well,
We'll meet that obstacle and cross that bridge fairly soon.
In addition, Wåho Menendez is aware of this. I mean, the relationship ends because of this. He's aware of the incident. He's not there to see it, but and that's why the relationship ends, is that they discuss what happens.
Has there been some evidence of that? Or will that be from the witness herself saying that she discussed it?
Yeah, she will be able to testify to that.
All right. All right, this area has been covered during the defense case, and most of it has been received without objection by the prosecution, or probably all of it. And that this is just corroborative of evidence presented primarily through the testimony of the defendants, and therefore the court will permit the defense to introduce this evidence. It's not cumulative at this point, and it does tend to prove those matters that the defense seeks to prove in its case. And there are certain aspects of her testimony, her personal opinions and things of that sort, that will not be admissible because they're not legally admissible evidence because of certain evidentiary rules. But the essence of what it is that the defense is offering here can be introduced. All right. So there are three areas then that Ms. Baker can testify about if the foundation is laid regarding the meal. She can testify about the Signorelli incident and about this incident here that we just discussed. And then council have given me the document of an interview of David Maravich. Rather lengthy report, most of which would seem to be inadmissible. Which portions are you seeking to offer here?
Just in a general sense, the witness's acquaintanceship with Erik simply as a foundation, that he knew him, when he knew him, what school he knew him, how long he knew him. I'm not going to offer his opinions about the parents because I do think there's enough of that in the case. I'm not going to offer the tennis tournament because I think there's enough of that as well. I think I'm mainly focusing on, let's see if there's something. Yeah, the only incident that's reported here from those early years that I'd be interested in putting on is Mrs. Menendez's extreme explosive behavior at the New Jersey DMV, because this is one of the few times that, and this is occurring in front of Erik, and it's one of the few, this is the only non-relative witness who ever saw her lose it. And just to show that it did happen even in front of strangers, that she would explode and be incredibly aggressive and confrontational with people. So that incident, very briefly, namely her losing it. And the other thing I'm interested in is the conversation that my client had with Mr. Maravich concerning Dr. Oziel.
I didn't notice that there was a specific date or time frame for this other than sometime after August 21st.
We can prove through extrinsic evidence that the trip to Cancun was November. That's where Erik Menendez went after the session with Dr. Oziel on November 2nd. He said he was going on vacation. I can prove through this witness and with extrinsic evidence as well that this is a trip to Mexico in November of 1989.
And that this conversation preceded that?
This conversation took place on that trip.
No, there was a phone call according to your report here. The initial initial conversation on page 10, the last paragraph, I assume was a phone call.
No. No, actually, the witness is here, we interviewed him last night, that's misleading.
Well, it says David talked to Erik again on 8/21/89 when Erik called him during David's first month at
Right.
college. Erik wanted to go on vacation and Erik was seeing some psychologist and then blah, blah, blah.
Yeah, but Mr. Maravich, in interview, told us that conversation about the psychologist occurred in Cancun. The phone call set up the vacation together, and it was just a few days before they went.
And the Cancun trip occurred after
November 2nd.
after November 2nd.
Yeah, I believe it's November 7th is what the travel record showed. November 7th?
And how is that going to be relevant then to the defendant's state of mind on October 31st and November the 2nd?
It's relevant, Your Honor, to the state of mind he's testified to at the close of the November 2nd session, that he felt that Dr. Oziel was not someone he could trust, that he felt that Dr. Oziel had ulterior motives. I don't see any.
Does that then not relate to the fact that Erik Menendez continued to see Dr. Oziel after that?
No, I don't think it relates to that fact. I think it might explain why he continued to see him after that, but no one's gone into that and we weren't intending on it. But it has to do, I suppose, if you think someone's blackmailing you, you may go and continue to see them. Now, we haven't put that on the record for obvious reasons because you don't want to open that up. But the fact of the matter is, Erik has testified to his state of mind at the end of that November 2nd session, how uneasy he was with Dr. Oziel. He is being impeached in his cross-examination, and this corroborates that shortly thereafter, he tells an independent witness that he has these misgivings about Dr. Oziel, that he doesn't trust him, that he thinks he has another agenda. And I would point out that in interviewing the witness last night, he recalled another specific portion of the conversation was that the psychologist wanted Erik to invest in businesses with him. And so this corroborates Mr. Menendez's testimony that, number one, that was his impression of Dr. Oziel at the end of November 2nd, and that impression was based on conversations that occurred during that session, which Dr. Oziel did not testify to.
People wish to respond?
Yes, Your Honor, the incident at the DMV counter, other incidences that have already been testified to, I believe we have something more recent, which was after the family moved to California. Somebody, and I believe it might have been Wyoming, has testified to an incident at a ticket counter at an airport where Mrs. Menendez was quite irate with her husband. And
Well, they're offering this as some independent evidence outside the testimony of the defendants to show that their testimony was accurate.
Well, we also have had relatives testify. I believe Ellen Anderson testified that she used to pick up dishes and throw them. And we made that kind of behavior on her part has been amply gone through already by defense witnesses. And as far as the statement that was made in November after the 2 sessions with Dr. Oziel, it's totally irrelevant to any issues in this case. Either the people's version of what happened during those sessions or the defendant's version, it wouldn't be out of the ordinary to think that there was feelings of unease between all the participants in these sessions. And basically, his statement that he did not trust Dr. Oziel, I guess, is being offered as a prior consistent statement, but the motivation for fabrication would have arisen when Erik Menendez realized that he made a mistake in going to see Dr. Oziel, and so I don't think it's admissible.
Well, he wouldn't be talking about Dr. Oziel at all in that situation. Then why would he be telling someone else about Oziel and that Oziel knew something?
Well, I don't believe that he's indicating here that Dr. Oziel knew anything specifically, just that Dr. Oziel was treating him for his psychological problems and he did not really trust him. I don't think this is relevant to any of the issues in the case. It occurs after the 2 sessions. If it occurred before the sessions or between October 31st and November 2nd, then I can see it might be relevant because some of the issues have been placed in dispute. But after those 2 sessions occurred, I don't think it's relevant what he has to say to any issues that are important in this case. I don't think Mr. Meredith has anything to contribute that is novel or corroborative.
Your Honor, Mr. Kuriyama was even questioning Mr. Menendez over my objection the other day about did he think Dr. Oziel was someone he could rely on. I mean, they have been trying to establish that Erik Menendez trusted Dr. Oziel.
Well, your objection had to do with a pre-existing relationship, and you were attempting to assert a patient-therapist privilege to earlier sessions, and you were also asserting a patient-therapist privilege to later sessions. Yet we know that the defendant, Erik Menendez, met with Oziel later. It's been documented on these sheets and billings that we have. And the issue is whether this conduct or the statements is actually a reflection of his state of mind as to what was going to happen in his relationship with Oziel, or it reflects his state of mind as to what had already happened with Oziel. That's the issue here as to whether it's relevant.
I think what it reflects, coming 5 days after the session of November 2nd, given Erik Menendez's testimony about what was said in that session and what was not said, this corroborates his description of what he did and didn't say in effect to Dr. Oziel. Because the people have made much of, well, you told him this detail and you told him that detail, and you want us to believe you didn't tell him these other details.
It doesn't do that at all. I don't see how you could say that somebody who edits or says he edited his statements by saying he killed his parents but didn't say why he killed his parents somehow is corroborated by this sort of statement that he didn't trust the person to whom he made the disclosures.
Because he didn't, the people have made much of the fact that he would not admit to Dr. Oziel that he was molested during these sessions, and that bears on the issue of whether he really trusted him. And it has to do with whether or not he and his brother would have been willing to say the things to Dr. Oziel that Dr. Oziel made up in our opinion, and later claimed they said. It bears directly on his feelings about Dr. Oziel following that session when he has told us what it was about that session that made him uneasy, particularly the discussion about financial involvement in the future, which Mr. Maravich says Mr. Menendez told him within a week of that session. Now, although Erik Menendez has another session with Dr. Oziel on November 28th, weeks later, we don't have before us the circumstances of how that or why that came about. That is something we are trying to avoid having to litigate. I can make an in-camera offer of proof if the court likes, but I don't see that that bears on this, because this state of mind reflects what happened at the previous sessions and the unease that Dr. Oziel's behavior created in Erik, which has been, clearly his credibility on that issue has been challenged, as on every other issue here. And so I think this is a prior consistent statement of state of mind with respect to Dr. Oziel. In fact, it's state of mind, period, with respect to Dr. Oziel and whether or not he truly trusts him or not. I know that people are going to argue, oh, you know, he went to his therapist, he'd been seeing him for a year. If this molestation had happened, we would have talked about it, and this bears on why it didn't.
Your Honor,
Yes.
I think that this particular portion of the report is far too speculative. It's just as likely that he didn't trust Dr. Oziel because Dr. Oziel knew that he committed a premeditated murder and that Dr. Oziel had taken precautions to protect himself by making tapes he put in a safety deposit box. I mean, you can argue all kinds of things from it, but when you have evidence from which you can argue all kinds of speculative things, I think that evidence is speculative and should not be admissible.
What the witness is going to say is that Erik told him that he was seeing this psychologist he didn't really trust because the psychologist did not seem interested in helping him with his depression or with how he felt. And he didn't really understand what good he would get out of continuing to see the guy. The guy seemed more interested in the fact that he was going to come into a great deal of money and wanted Erik to invest the money with him. And he was also, in this discussion, Erik also indicated that the psychologist was not someone he had originally chosen, but someone he was directed to, I think was the witness's statement.
When was this statement obtained, the one that is presented to me, the written statement?
When was the statement obtained to Mr. Maravich? In the last 2 months.
It doesn't have any of the information that you just related to me that you say Maravich would testify about.
I understand that, Your Honor, but I interviewed him last night to prepare him to testify and asked him to expand upon this. The statement was taken by our investigator. And in July, this statement was taken, it's a very long statement, so this is somewhat truncated, but Ms. Morrissey and I interviewed him with our other investigators present last night at some length, particularly about this segment, and that is what he told us. Now, he lives in New Jersey, and he hasn't been here. As far as we know, he has not been following the trial.
Why is,
Pennsylvania now? He's at the University.
well, it really, what I'm observing has nothing to do with its admissibility so much as it's the weight, the fact that these things all come out now and didn't come out in July when he was interviewed.
It was a very lengthy interview, as you can see, covering a great many topics, and so we focused on the part that was important to us, because out of all of this, given all the other witnesses, the only two parts we want is the DMV episode and this.
Well, in regards to the episode at the Department of Motor Vehicles, it is fairly brief and is evidence of someone other than a family member and other than the defendant, so I'll permit it. In regards to the state of mind evidence offered here, I don't see this as prior consistent statements of Erik Menendez per se. The only real basis for its admissibility would be if it's evidence of his state of mind at that time. And the issue is whether that state of mind at the time he made these statements is an issue in dispute in this case. It's an issue in this action.
I think his state of mind, in effect, is circumstantial evidence of the nature of the conversations that took place during the session with Dr. Azil of November 2nd. It is in teaching of Dr. Azil's version and corroborative of Erik Menendez's version. If things had gone in that session the way Dr. Azil claimed, we submit Erik Menendez would not have had this state of mind afterwards.
Your Honor, it would appear then that it is being offered for the truth of the matter asserted, which is that Dr. Azil had wanted to have these kinds of investments or has some sort of financial interest in Erik Menendez. So it's not offered just to show a state of mind, it's offered to show that that is in fact what went on during the session. So it is hearsay still. And his state of mind after those sessions, I believe, is not relevant to anything that follows from that. Certainly the November 28th and December 11th sessions are not an issue. The subsequent relationship with Mr. Erik Menendez and Dr. Azil has not been anything that has been testified to or is an issue at this time. And so for that reason, his state of mind in November.
Well, the issue is whether the evidence is offered to prove the declarant, in this case, the defendant Erik Menendez's state of mind, emotion, or physical sensation at the time he made the statement or at any other time when it is itself an issue in the action. And it's not the state of mind on November 4th or 5th is not an issue in this case. The state of mind on August the 20th and also state of mind at the time he spoke with Dr. Azil during the two sessions that are at issue here, the 31st of October and November the 2nd are at issue. And the question is whether or not what he said to this individual subsequent to October 31st and November 2nd reflects his state of mind as it existed on those two dates, when it would have some relevance and be an issue in the matter in some fashion.
Your Honor, it's only a few days after this session where he gives a very disputed account from Dr. Azil. And according to Mr. Menendez's account, Dr. Azil's behavior was such that it made him suspicious of Dr. Azil, untrusting of Dr. Azil, and therefore, and the fact that he had that state of mind was based on the fact that Dr. Azil was saying things very differently from how Dr. Azil testified here. Now, Dr. Azil's credibility on this issue is clearly an issue. Erik Menendez's credibility of what was said in the November 2nd session is clearly an issue. Erik Menendez's avowed state of mind at the end of that session bears on his credibility as to what happened during that session. And we are only 3 days later, and there's been no contact with Dr. Azil, as we know from Dr. Azil's testimony, between Erik Menendez and Dr. Azil before the time that Erik Menendez makes the statement to David Maravich. So his state of mind at the time he's making the statement to David Maravich has got to come from, and only come from, these last contacts he's had with Dr. Azil. Now, as logically relevant, if things had gone the way Dr. Azil said, where there's no mention of money, and where he's not trying to exploit these two young men, where they have a conversation where the defendants freely and fully discuss this incredibly negative information that he claims they gave him, then you would not suspect that Erik Menendez would be talking about how he doesn't trust him, how he doesn't feel he's helping him, and how he is suspicious of his motives because of discussions about money. So I can't see how Erik's state of mind as circumstantial evidence of what was said in that session is an issue, because what was said in the session is an issue. And 3 or 4 days later, that same state of mind could not have any other intervening factor. It has to still be based on what happened during that session, and it's still an issue.
Now, what happens
All
after
right.
November?
To some extent, the jury, no matter what happens here, is not getting the full flavor of this whole thing because we all know that the defendants went to see Dr. Oziel on several occasions after this. And you have your theory as to why they did. The people have their theory as to why they did. But those visits could very well be regarded as inconsistent with this expression of state of mind that you're offering here. But that's beside the point. The court does recall that the people offered evidence of Dr. Lulo in regards to the state of mind of Dr. Oziel after the October 31st events. And the people's theory was that that was a reflection of Dr. Oziel's state of mind. How is this different from that?
Because what is sought to be proved here is not proved by what Mr. Marovich would testify to. They're saying that the distrust of Dr. Oziel must necessarily have flowed from a version of the events that Erik Menendez said occurred. In other words, Erik Menendez did not trust Dr. Oziel because Erik Menendez's version of what happened during those two sessions is correct. It is just as likely that Erik Menendez's distrust of Dr. Oziel was because Dr. Oziel was now in possession of information that could send him to the gas chamber. And in addition, Dr. Oziel had acted to protect himself from the brothers by making tape recordings and putting them in a safety deposit box and conveying this information to the defense. That is contrasted with Dr. Lulo, who testified to first of all, it was shortly after the incident. It was the same night that Dr. Lulo talked to Dr. Oziel. And from Dr. Lulo, you can only infer one thing, which was that Dr. Oziel was in possession of information which had frightened him. I don't think the same can be said about the statement of Erik Menendez that he did not trust Dr. Oziel some 5 days after his last visit with Dr. Oziel. And I don't think that it proves that which it seeks to prove. It proves either version. And so it's not corroborative and it is not circumstantial evidence.
All right, the court at this stage will rule that it is circumstantial evidence of his state of mind at the time of the conversation. It does fall within that category of evidence that can be interpreted more than one way, and it will be most likely up to counsel to argue the quality of the evidence and what it means. But as far as its admissibility, that's a separate issue, and how the parties choose to use it later on in argument is for them to resolve. But as far as its admissibility, it does seem to fit the qualifications for admissibility of evidence of a existing state of mind that is relevant to an issue in dispute in the case, and therefore would be admissible, and therefore the court would permit it.
Your Honor, would that be with a limiting instruction that is not offered for the truth of the matter asserted, but rather to reflect the declarant's state of mind?
That's why it's being offered, and I assume the defense would agree with that. Okay.
So the court will so admonish the jury?
Yes.
Thank you.
Anything else that counsel wish to discuss relating to other testimony?
Yes, Your Honor. I believe I've been speaking with the defense about the scheduling, especially for next week. And for Wednesday, there are 3 witnesses listed, Dr. Cox, Emery, and Summerfield. And rather than have them come in here and wait around, I thought perhaps we could discuss the propriety of their testimony before we get to this Wednesday.
Yeah, I'm not comfortable discussing that right now, Your Honor, because I don't have the materials with me today, and I didn't know that was coming out.
All right, that was a matter that had been discussed earlier relating to the testimony of psychologists who had treated Mrs. Menendez and who had some contacts with Mr. Menendez as the spouse of the patient. And the issue was whether or not this evidence would be admissible. Both sides had filed briefs on the matter, but the court had ruled that the substance of the issue in dispute would not be resolved until after the defendants had testified, because the defense had indicated primarily that the testimony of those witnesses would be offered to corroborate the defendant's testimony. And the court felt that it could not evaluate that offer until after the defendants had testified, and deferred ruling on whether it would be admissible until after that. And I did not indicate whether I would find this evidence admissible or not, just deferring the hearing on the matter. And if counsel feel that you want to review the materials that you prepared on the subject before you want to discuss it, we can do that. I don't anticipate this evidence or this hearing to take very long. It's already been briefed, and it's not going to consume very much time. I don't want to put counsel in a position, however, that you're not prepared to argue the matter. If you feel that you need to review your materials before doing that, I'll give you that chance. However, I want you to have other witnesses available to fill in for them if they do not testify, so that we don't have a situation where we're faced with a schedule of witnesses for Wednesday and ultimately they are not permitted to testify. No, it's an indication that we lost a lot of time in this trial, and I don't want to lose any more time.
Then we'd rather have a ruling now, Your Honor, because the nightmare of scheduling.
All right, are you all ready to deal with that now, or do you want to do it after lunch, after you review your materials, or how do you want to proceed?
Can we do it tomorrow? If it's not going to take very long. Half an hour, you think would be sufficient?
I would think so. It's not going to take very long. As I said, I don't want to put you in a position where it's been a month since you've looked at your materials and you don't feel comfortable. Okay, but as I said, I don't think it will take very long, because it's material that has been briefed, and counsel for the defense has submitted to me the reports of these individuals, so I know what it is that you propose that they'll say. And so just additional argument to supplement what you put in writing. Right.
There are other witnesses scheduled for next Friday who are family members from Mrs. Menendez's side of the family. Joan Vandermolen, who I believe is her older sister, and Pat Anderson. They were originally are now returning, and also there's an Arnie Vandermolen who was not originally scheduled. And we would object to any more family members. We're not objecting to Carlos Barat because he's the executor of the estate. But as far as the two Vandermolens and Pat Anderson, we are objecting. I don't know precisely what these witnesses will testify to, but it would appear that the nature of what they would testify to is either cumulative or irrelevant. I know some of it deals with family history. Mary Louise Menendez's relationship with her family as a child, and I don't know what Arnie Vandermolen testified to.
And these are witnesses scheduled for next Friday, not for tomorrow, but
That's correct. But the reason I'm bringing it up now is I believe that they're out of state, and in order to not bring them out, if they're not going to testify, there's no reason to incur the expense of bringing them.
I have reports that were submitted to me regarding the interviews of Joan Vandermolen and Pat Anderson. I don't have anything regarding Arnie Vandermolen.
It appears we have scheduling problems, and I at this point, it does not appear that Arnie Vandermolen is going to be able to.
All right,
Mrs. Suzanne,
so let's
that
not,
changes, we will let her know, but it doesn't appear at this time he will be testifying.
okay, so then we just have those two ladies. Did you intend to offer everything in those reports, or just portions of them? And if it's only portions, perhaps you can provide me with a copy of the report, which would only contain or refer to those things that you do intend to offer, and then we'll be in a position to evaluate it at that point.
Can we do that tomorrow as well, Your Honor?
Well, tomorrow or whenever we get time to do it, but at least you can give it to me and I can review it. And if we have time tomorrow to fit it in, that's fine. But I do want to finish the testimony of Erik Menendez, however, I'm sure everybody else does as well. Are there any other matters that deal with testimony of witnesses and things of that nature that require hearings beforehand?
It was my understanding that Mark Cano is going to be testifying to the conversation about the defendants believing that they were out of their will. Is that, I think that's the reason that she's being called. Is that,
I'm sorry. I missed that.
Mark Cano's being called to relay the conversation she had with the defendants about their belief that they were out of their will.
And the lack of knowledge about insurance policies. The conversation that she testified to on a 402, Your Honor, where the court ruled that testimony would have to wait until after the defendants testified.
If that is in fact what she's going to testify to, I think I'm not going to object.
That's all.
I don't think I can. I think it's prior consistent statement.
Well, the court did rule that those statements would not be admissible at the time they were being offered based on the lack of reliability or not meeting the criteria of Section 1252 of trustworthiness. But at this stage of the proceedings, as the court indicated, the court's concern was that the credibility of the defendants was at issue, and it's something that because of the timing of those statements, if the defendants did not testify and if their credibility wasn't before the jury, there was a situation where the circumstances did not indicate trustworthiness or indicated just the opposite, lack of trustworthiness. However, now it's really an issue for the jury to resolve as to whether these statements were trustworthy or not, or whether they were truthful or not. They've had a chance to evaluate the credibility of the defendants, and we'll have that opportunity during their deliberations. And if they made some statement shortly after the killing of the parents, the jury can make the evaluation as to whether those statements were a true reflection of their state of mind or whether it was a fabrication. And there's no reason for the court to bar that evidence at this point. The jury should make that determination. However, her personal opinion as to whether they were or were not surprised would be just that, a personal opinion, and would not be admissible. But what was said would be. Depends on how they're described. If they're in relationship to a personal opinion, they would not be admissible. All right. Anything else in relationship to any other matters? Dealing with hearings that must occur prior to testimony.
Well, Your Honor, I believe that when we get to some of the witnesses dealing with Dr. Oziel, that there are going to be objections, especially to a Dr. Golding, who I have an idea that he's a witness on professional standards for psychologists. That's pretty much what he is.
Ethics and confidence.
And we're going to object to his testimony. And then we're discussing right now with the defense Ms. Smith's testimony, and then Alex Curry and a man named Mr. Phipps, who I think the court got a report on.
The court ruled on Mr. Phipps.
Did the court already rule on Mr.
Yes.
Phipps?
Male with.
That was a ruling, and then they were trying to get him in for brief testimony, and he couldn't come in on a date that we had some other witness scheduled.
And then Alex Curry, I don't think we've had a ruling on yet.
I haven't been presented with anything regarding her testimony other than the complaint or accusation filed by the State Board of Psychology and some document that she faxed to the court and that the court provided to counsel. But I have not been provided with any reports regarding her testimony.
Okay, Your Honor, I have a copy here I can provide to the court.
Well, perhaps before you provide it to the court, is that an interview by the defense?
Yes, it is.
That the defense can review it and identify those things that the defense seeks to offer in her testimony, so I don't have to read the whole thing that wouldn't relate to the offer of proof. So ask that the defense review that report and identify for me what it is that you want to introduce, so I'll be in a position to evaluate that. And we'll have to wait until they've done that and I've had a chance to read it before I can conduct a hearing on that.
I just wanted to notify the court of what I thought the hearings were going to be in the near future.
Okay. And assuming the testimony of Erik Menendez is completed tomorrow, what is the current thinking of the parties as far as when the defense evidence would be completed?
A day later than we originally, a day or two later than we originally estimated because we lost time due to illness.
Well, the schedule you gave me last, dated September the 28th, called for completion of testimony on Tuesday, October the 19th.
I think we're more looking at the 22nd or the 25th. I think we bumped up to, we were already up to the 21st from the revised schedule that we did yesterday. I think that the 22nd is realistic. If we can get witnesses in and, you know.
What about the people's rebuttal at this stage?
No more than 7 court days, hopefully less.
All right, so you're talking going into beginning of November in testimony.
Correct. Now,
All right,
are we gonna be in session that first week?
yeah, if we're in testimony, we'll be in session.
I just need to know.
You wanted some time to have between the completion of testimony and beginning of argument to review your materials.
That's just the bottom one. We have several.
Yeah.
Couple of days of several.
All right. If there is some time there towards the beginning of November when we won't be in session, I'll let you know.
Yes, the court needs that conference. We keep it as to-
It wouldn't be, it would just be a couple of days at most.
Well, we could use, I mean, since we'd be almost at the end of the trial, we could use those as the days to prepare for argument.
That's true.
Even with a couple more witnesses coming.
Yeah,
That's true.
with the rebuttal, each witness shouldn't be a very long witness.
Okay. All right, we'll be in recess then until tomorrow at 9 o'clock. Oh,
We're gonna be downtown.
that's right, 10 o'clock.